Thanks for responding, Michael. Can you let me know if you can hear this? Okay, just in case anybody's listening, we'll start in about a minute. So get yourself settled, grab your coffee, and do whatever you have to do. Oh, let me get my camera going. That's better. There we go. Okay, well, it is, excuse me, it is 1:18, so we should probably get going. Hopefully we've got more than the two people who've responded to me in the room. But let me start by introducing myself. My name is Stuart Rudner. I'm an employment lawyer and mediator. I'm also the founder of a law firm, Rudner Law, where all we do is practice in the area of employment law. And we work with employers and employees. So we see things from both sides. And just by way of brief introduction before I start talking about the current situation we're in, COVID-19, and what you need to know as an entrepreneur and as an employer. What we often say is that at the best of times, people don't take the time to understand their legal rights and their obligations when it comes to their employment relationships. And these are certainly not the best of times. We are dealing with an unprecedented situation where everyone is struggling to try to figure out what to do with respect to their business, let alone their workforce. And things changed almost overnight. It seemed like it was overnight, at least to me. And the challenges, of course, people reacted very hastily because they didn't have a choice, and often did things that weren't the best legally valid decisions. They often exposed themselves to liability. They missed opportunities to save money when it came to their employment and their workforce, and basically did things in the least strategic way that they could. And that's not unusual. One of our biggest frustrations among my team is that many of our clients, and we work with a lot of small, mid-sized businesses, a lot of entrepreneurs, a lot of growing companies, and we know that HR is often the last thing that you have time to think about. And one of the challenges that we have is that HR is one of the last things that you think about. So one of our goals is to help our clients make informed decisions. And we try to develop an ongoing relationship with our clients where we are one of their strategic partners or strategic advisors, giving them advice on one aspect of their business. One of our goals over the last, let's say, 8 or 9 weeks now has been to disseminate as much information as we can regarding employment issues in the COVID-19 world. I've done more webinars in the last 2 months than I've done in my life. We have posted hundreds of updates on our running blog on COVID-19, which I encourage you to check out. Our website is rudnerlaw.ca, which you'll see at the end. You'll have all our contact information. But we have a running blog on everything COVID-19 workplace related, which we've been updating. And for a while, it was 5 or 6 updates a day. Lately, it's a bit less, but there's still a lot of change. So we're doing everything we can to get information out there. Initially, the focus was on cost savings, layoffs, wage cuts, that kind of thing. I'm happy to see that the discussion is changing now. Now we're talking about back to work and how do you recall your employees, and what if they don't want to come back, and workplace safety obligations. Brings about a whole set of new questions, which I'm going to try to go through at least some today in the roughly half hour that we have. By the way, I should mention, I'm happy to stick around a little bit later. If we were doing this in person, then typically I'd be at the front of the room, and at the end of it, people would wander over and ask me questions. So I'm happy to do that virtually today and stick around for a few minutes and answer any questions you might have. Or if you prefer not, excuse me, not to answer them in a public forum like this, then you'll have my contact information, so you can feel free to email me, and I'm happy to help you as much as I can. So before I get into this, I will, sorry, let me just switch switch gears for a moment so I can change slides. Hopefully this will work. I will do the usual lawyerly thing and give you a disclaimer. And we've been taking this a lot more seriously recently because we always say that this is intended to be for informational purposes only and not legal advice. I cannot even say it more strongly than I will now in the COVID-19 world. Every situation is different, and the situation is constantly changing. That's why we've added this sentence here that says the information is current as of today, because things are changing so rapidly that the webinars we did a week or two ago may have things that are not quite accurate. So please, this is intended to give you some general advice, some general information, not legal advice, not a legal opinion. If you're going to be making decisions that could impact your rights or could expose you to liability, get proper advice. And I know, especially if you are in one of those businesses that has been all but shut down, you're not looking to spend any more money than you have to, but it's almost always money well spent to get proper legal advice before you do something rather than trying to fix it later. So that's my public service announcement, so to speak. In terms of what I want to talk about today, bringing workers back, safety in the workplace. That's where we're getting a lot of our questions. What happens if employees don't want to come back? Talk a little bit about the Qs or SUs, depending on how you pronounce it. I'm not going to get into too much detail because that could easily fill our half hour right there, but also the chance to take a bit of a more strategic approach to HR and what can we learn from this whole experience that we are still going through. And like I said, I'm happy to take your questions at the end, even if it means we go a little bit past 1:45. So getting right into it, and bear with me for a second. I'm just going to adjust my screen slightly. Oh, hi, Joanna. I see your comment. Nice to have you here. I wish I could see you, but nice to be with you. So before we even talk about bringing workers back, we need to talk about how or why they were gone in the first place. So as I said, when this all started back in mid-March, things happened so quickly. A lot of people reacted very hastily. We saw a lot of layoffs. And as I very publicly said, a lot of those businesses were laying off their employees probably didn't have the legal right to lay them off. And they exposed themselves to risk. And people have 2 years to bring a claim. So we'll have to wait and see what happens. And some people weren't formally laid off. They were just sent home, essentially. Some are paid, some are not paid. But it's important to remember that, what is a layoff? It's a temporary interruption in employment. We often talk about people being laid off, and we use it as a bit of a euphemism for someone being dismissed without cause. Those are two very different concepts, and we're going to talk about both. But when we talk about layoffs, we're talking about a temporary interruption. There is a right on the part of the employer to recall them, although you don't have to. We're going to talk about what happens if you don't. For people who have been laid off, they should be receiving either employment insurance benefits or the CERB, which was designed to supplement or replace EI, depending on the circumstances. Now, depending on which province you're in, I'm going to focus on Ontario, although we do work across the country. Every province is a little bit different. One important thing to remember as a business owner, employment laws are provincially regulated, which means every province has its own set of legislation, employment standards, human rights, occupational health and safety, etc. So it's important to understand that you need to be aware of which jurisdiction you're in. In Ontario, you can impose temporary layoffs of up to 13 weeks, as it says on the slide, in a 20-week period, but that can be extended to up to 35 weeks in a 52-week period if you do things like continue their benefits, top up their employment insurance, or other things that can extend the time period. But as the last bullet says, and I see the question from Nora, so thank you. As the last bullet says, if your temporary layoff exceeds the limitation period, that's a deemed termination. Some provinces don't have limits, so you can keep them on temporary layoff for an indefinite period of time. In Ontario, once you hit that either 13-week or 35-week threshold, it's a termination, and there's no discretion, there's no waiving the rights, there's no agreeing. You can never contract out of Employment Standards Act. So that's one very important thing to bear in mind. So the most popular question we're in these days, how do we bring people back? So either they're on a layoff or they've just been sent home, but either way, most companies have never done this. Most companies don't lay off their employees as a matter of course. And as I said, most companies don't have the right to, but assuming you did, and assuming the person's on layoff, there's so many myths and misunderstandings out there. The most common one is this belief that you have to hire or have to recall people based upon seniority or in the same order they were laid off. So another important point to remember, if you are unionized, if you have a collective agreement, that will have very clear procedures as to how you lay people off and how you recall them, how you bring them back. If you are not unionized, which will be the majority of people here, I expect, if not all, then unless you have a policy which talks about this, which would be very unlikely, you have basically full discretion as to who you bring back and when you bring them back, bearing in mind, of course, the time limits we talked about. But you can make these decisions on any basis or no basis at all, just like hiring and firing. Contrary to popular belief, I mean, you can hire the worst candidate. You can fire your best employee. There's nothing unlawful about that. Bearing in mind the two caveats here: no breaching human rights, so you can't make those decisions based upon grounds like gender or race or disability, which is particularly relevant because if someone tests positive for COVID-19, you can't discriminate on that basis. Obviously, you're not going to bring them back while they're still in a quarantine period, but you can't refuse to bring them back or fire them because of that. And no reprisal. So if someone has raised a safety concern, you can't get back at them, so to speak, by not recalling them. Other than that, it's up to you as to who you want to bring back and when. So with respect to, as I said before, how does it work? Every province is different. Generally, some will require written notice, some will not require written notice. Our advice is always to give written notice of when the person is expected to come back. And you can use that notice strategically too. We're working with a lot of our clients to put together notices, which do really three things. One, of course, tell the person when they're expected to return to work, and also that it's not optional, that they have to. But two, you can use the opportunity to reassure your employees about what you're doing to make sure that the workplace will be safe. And three, at the same time, let them know what the expectations are of them in terms of maintaining safety, what the new policies are, what the procedures are, so they know that they are expected to comply with all the safety policies you're putting in place, and that there could be discipline if they don't. The other question we're getting a lot of is if we bring people back and we bring them back part-time, reduced hours, reduced wages, reassign them to a different role. So the answer is going to be very careful about that, because you might be risking a constructive dismissal, which I believe is my next slide. Yes. So I want to talk about constructive dismissal. This comes up as the question says here: did you lay off your employees or reduce their hours and pay, or are you thinking about doing so? So you need to know what a constructive dismissal is. As it says on the slide, it is a unilateral and substantial change to a fundamental term of the employment relationship. So let's talk about layoffs first. Think about the very basic nature of the employment relationship. It's that the employee will work and the employer will pay them to do so. If you go to your employee and say that for the next little while, you're not going to work and we're not going to pay you, you are most definitely changing the very nature of the contract, which would be the very definition of a constructive dismissal if you don't have the rights. As it says here, if the contract gives you the right, you're free to do it. But don't be misled by the fact that Employment Standards Act talks about how you implement layoffs. It talks about the method for doing so. It doesn't give you the right. I will pat my team on the back for a moment here, because we have been advising our employer clients for years to put temporary layoff clauses in their contracts. And we often get pushback. And people say, we don't lay people off. That's not us. And we'll usually say, put it in just in case. We never imagine a scenario like the one we're in now. But a lot of our clients are thanking us because there's no ambiguity. There's no question about whether they can lay people off or not. They have the right. Other businesses are basically taking a chance. Same thing for modified duties, modified hours. The only difference there is, will it be a substantial change or not? And there are, contrary to popular belief, there are no absolute rules. Some people think that anything less than a 15% decrease in pay will not be constructive dismissal. That's not necessarily true. Other people, I've heard 30%, I've heard 25%. Every case will be assessed on its own particular facts. If it's a nominal change, you're probably fine. But before you go about, totally changing someone's job or cutting their pay in half or cutting their hours in half, get proper legal advice, because that could be a constructive dismissal. And I guess the one thing I will add to this, as the last bullet says, will the existing laws be applied as they were before? This is a matter of a lot of debate amongst myself and my colleagues about whether constructive dismissal will be applied in the COVID-19 context. So historically, there's no question that laying somebody off, if you didn't have the right, is a constructive dismissal. And the financial circumstances of the company, of the world for that matter, were not relevant. It's entirely possible that a judge at some point will look at this and say, you know what, we need to adapt the law. But that's not going to happen for years. We're not going to see a final judgment on that, because undoubtedly any judgment will be appealed. We're not going to see a final judgment on that for years. So you're waiting and hoping until then, if you've gone ahead and laid somebody off, or if you make these substantial changes and hope you can rely upon COVID-19 as an excuse. You may win at the end of the day. And it wouldn't surprise me at all if a judge says that, you know what, it's not right, it's not fair to employers to tell them that on the one hand, their revenues have been decreased by 50, 70, 100%, and yet they have to keep paying their employees. I agree, it doesn't make any sense at all, but that's the way the law is now. That might change, but it hasn't changed yet. So just moving forward, if there is either a regular dismissal, and a lot of our clients are taking this chance to reevaluate their workforce and assess whether they need everyone, and if not, who really they don't want to keep anymore. And it could be just a simple dismissal without cause. It could be a constructive dismissal. It could be a deemed dismissal where there's a temporary layoff that went too long. In any of those cases, you've now arrived at a termination. And when there's a termination, you have to provide either notice or pay in lieu. So there are more myths and misconceptions that I can possibly cover in a few minutes now. But by way of a high-level summary, if you let somebody go without cause, in other words, a dismissal, you have to consider three potential sources of the entitlement to assess how much do they get. Employment standards legislation sets out the absolute minimum that someone can get. Common law says everyone is entitled to reasonable notice. And contrary to popular belief, it's not a week per year, it's not a month per year. Our courts have said they're going to look at a bunch of factors, including length of service, of course, but also the employee's age, the nature of their job, i.e. is it clerical, sales, managerial, are they an executive, and the availability of similar work. And they're going to try to figure out what is an appropriate period of time for them to need to find new work. The maximum is generally 2 years. So that should give you an extent of your potential obligation here. If you either intentionally or unintentionally dismiss someone, it could be 2 years. It can be more if there are exceptional circumstances, but that should be enough to make you think twice. And the last point here, or last potential source, is contract. And I will mention this again at the end, but I'll say it now because it's the best thing you can do as an employer is strategically use contracts to minimize your severance obligations. And just a quick example, take a 20-year employee who is in her 50s and in a sales job. If you let her go and there's no contract, you're probably on the hook for at least 1.5 years of severance. With a contract, that could be as little as 8 weeks. So that's why contracts can be extremely strategic. So you need to assess if you either dismiss someone intentionally or unintentionally, you're going to be on the hook for severance. You need to figure out how much. So moving forward, because I am mindful of time, the other big issue or big area of questions we're getting now is safety in the workplace. What do we have to do as we bring people back? So start from the proposition that every employer has a duty to take all reasonable steps to ensure a safe work environment. Doesn't mean you have to guarantee one, because that's not possible. Take all reasonable steps. If you have a health and safety committee, or if you have someone who is your health and safety person, get them involved. And then you need to assess the workplace or workplaces and all the potential risks. And if you have someone that can work from home, that's the ideal. If remote work is possible for some workers, they should be allowed to continue working remotely. Otherwise, consider reorganizing your workplace so that you are maintaining physical distancing as much as possible. And a number of our clients are reconfiguring the workplace right now. Make sure that you have PPE, personal protective equipment, masks, gloves, soap, hand sanitizer. All these things are probably going to be important depending on the nature of your workplace. And by the way, thank you, Nora, for the question. Question is, how about workplaces like live theater where you just can't bring people back yet? If you can't, you can't. And of course, as we know, some businesses are permitted to open, some are not. And if you can't reopen, you don't have to reopen. But the discussion here is really, if you are able to and ready to reopen, how do you do it? And how do you maintain a safe work environment? So testing, I often get questions these days about, can we require temperature testing? Can we require they provide, if someone tested positive for COVID-19, can we require a doctor's note? This gets very challenging because you're balancing two legal duties. You have a duty to provide a safe work environment. You also have a duty to respect their privacy rights. And anything that infringes upon their privacy rights is going to have to be justified. Temperature testing is a hard one because on one hand, it's not always reliable. Someone might have the virus and not test positive. And second of all, it is intrusive. So you are going to have to justify it. And just because one business does it, doesn't mean everyone can. It will depend on the nature of the business. For example, food processing plants are doing temperature testing, and it's justifiable. If it's a healthcare facility, it's justifiable. If you're in an office, probably not. So you're going to have to assess that and decide if it is justifiable or not. So the other question I'm getting a lot of, what about when I call my employee who's been home for the last 7 or 8 weeks now, and they don't want to come back. They prefer to be at home with their kids. They're still worried about the virus. They prefer to remote work rather than come back to the workplace. I think it's really important to understand that coming to work is not an option. So it's no different if you were in normal times and you work Monday and Tuesday. You can't just decide I'm not going to go to work on Wednesday. It's the same thing if you were on layoff and now you've been recalled. You can't just decide that you prefer not to. There's a few exceptions on the slides up on the screen. First of all, refusing unsafe work, which I will talk about in a little bit more detail. Second of all, if there is a need for accommodation. So for example, if the person has a health condition that puts them at greater risk than others, they may have a legitimate need for accommodation, which might mean not coming back to work, might mean remote work, modified duties, etc. Or someone has children and they have childcare obligations. They may need to be accommodated for that. And I mentioned leave of absence because in a lot of provinces, including Ontario, we had special leaves of absences put in place for people who cannot work due to COVID-19. Important to remember for both accommodation and for leave, this is a need, not a preference. So it's someone who cannot work. Take the childcare, for example. It's not that they prefer to stay home with their kids, but they have other options. It's that it's the only option and it's a need. So that's the threshold they have to show to either establish a leave of absence entitlement or an entitlement to accommodation. And then you can assess whether you can accommodate them. What we're encouraging our clients to do, if you have an employee who says, look, I don't want to come back to work, engage in the conversation. Try to find out why and try to reassure them if they have concerns. But also think about your needs because you may not need everyone back. So if you only need half of your workers back right now, it might work to your benefit to have someone stay on leave if they don't want to come back anyways. So you can then just keep them on leave if you agree to. But otherwise, if you need them back and they refuse and they don't have a lawful reason, then you can threaten, issue a warning. But ultimately, it needs to be made clear they will be abandoning their job. It'll be a resignation if they don't come back, and they need to understand that. So I talked about briefly about the right to refuse unsafe work. Every province's occupational health and safety legislation addresses this. And the point is the same in every case. If there is genuine concern about unsafe work conditions, then a worker has a right to refuse. It must be a legitimate concern. It must be specific to the workplace. In other words, not a fear of going out in public, but a fear that there is danger in the workplace. So as part, when you're bringing people back, you're going to want to have very clear policies and procedures. You're going to have your general health and safety policies. Hopefully you already have them anyways. If you don't, you should be aware that legislatively you're required to. So if you don't, you need to make sure that you put those in place very quickly. But you're also probably going to have new policies and new procedures, COVID-19 related. You want to make sure everyone knows what they are, but you also want to make it very clear what is the process if someone feels as though their workplace is unsafe. Because the first step, if somebody does, is they're supposed to raise the concern internally to the employer, and the employer must then investigate, assess whether there is a risk or not, and advise the employee of what's going to happen or if they think that it is safe. If the employee is not satisfied with that, they can go to the Ministry of Labor. And I can tell you the Ministry of Labor has bolstered its resources. They've actually reached out to retired inspectors. They've transferred inspectors from other departments to make sure they have enough capacity to respond to these requests. I've also heard that there have been over 200 complaints of unsafe work environments over the last little while. Interestingly, none of them have been upheld. In other words, in every case, the ministry has found that the workplace was safe. So that's entirely possible, but you may have to go through the process if the employee is not satisfied. So moving forward, I mentioned the emergency wage subsidy, the CEWS or CEWS. I could spend hours talking about this, but just to give a high level, I think a lot of people probably know this by now. What the federal government will do is they will pay up to 75% of an employee's initial or basic $58,700 salary. So in other words, up to $847 per week to employees. Now, it's critical that they not be laid off. You can't get the subsidy for someone who's been laid off. The whole purpose of this is to prevent or reverse layoffs. So if you have laid somebody off, but you want to get the subsidy, you've got to bring them back. If you do, one of the questions we often get is, do you have to pay the other 25%? And the answer is not necessarily. The legislation doesn't require it. What the federal government has said many times is that they expect businesses to make best efforts to do so, but they're not checking for that yet. So what we're telling our clients to do, if you're not going to top up the employee to 100%, document your reasons why. You may be called upon to show at some point why you didn't. So include the calculations, whatever you've done to reach the conclusion you can't. And on the flip side, it's not all or nothing. You could top it up with 5% if that's all that you can afford to do in these circumstances, and that will be okay. But that's certainly going to look better than just saying we're not going to do anything at all. So in case anybody hasn't heard, initially this was supposed to go from March 15th to June 4th. It was extended through the summer to August 29th. You will qualify if you've had a reduction in revenue in the first month. It had to be 15%. After that, it's 30%. And as mentioned before, the employee can't be on layoff, which is true. Doesn't mean they have to be working. And a lot of our clients have called people back, but they're basically being paid to be at home. And in many cases, they're only getting the subsidy, but nothing more. So that can be a great option. First of all, if you have somebody on layoff and you're getting up to the time limits I talked about earlier, but you don't want there to be a deemed termination, bring them back. And if you can't afford to pay them, use the subsidy. And at least they'll get 75% up to $847 a week, and they will continue to be employed. There's still a risk of a constructive dismissal claim there because you're paying them less than their contract requires. And just as a bit of an aside, every employee has a contract. If it's not in writing, it's a combination of whatever was discussed verbally with a whole bunch of things that are implied by law and your past practice. All of that basically becomes their contract. But every employee has a contract, and you're far better off if you have that in writing. So last point, and I actually thought I had another slide, but I guess not. But what I wanted to say to everyone is, we are, in our firm, we're big proponents of strategic HR. In other words, we all know that the employment laws are designed to protect employees. We also know that some things can't be changed, but a lot can. You can greatly improve your legal situation through contracts, through policies, through procedures. And that's always the case, but now is a great time to take a step back and look. So as I mentioned before, if your contract has a temporary layoff clause, you're in far better shape than the vast majority of employers. If it doesn't, now's the time to update your contracts. If your contract has a strong termination clause that is enforceable, and that's a big if, you're in far better shape than most employers. There have been hundreds of legal battles in the last few years over termination clauses, and we are confident that we can help you put one together that will be enforceable and not struck out by a court. So update your contracts to have strong termination clauses as well. The other thing to do now is take a step back, especially if your business is slower than usual. You've got more time to look at things like policies than you normally do. So think about what didn't work very well. What were your health and safety policies helpful as you went through this process, or do you need to change them? Did you have a remote work policy? If not, you need to implement one. Maybe you have to update it. Did you have sick leave policies that may have been not quite ready to adapt to a COVID-19 world? Now's the time to think about your policies and adapt them to be as strategic as you possibly can. On that front, I will encourage any of you to reach out, and I'm happy to take a look if you have contracts, if you have policies in place. I'm happy to take a quick look and give you some thoughts. No cost, no obligation, but just to see, because like I said, we're big believers in strategic HR. It will help you to avoid a lot of problems down the road and just put yourself in better shape than you would be otherwise. So I'm still mindful of time as I will advance. I mentioned the writing blog before. There's the link to it, and I see the next slide is actually the one I was thinking of. So this is what I was talking about a moment ago. Be strategic. Take the time to think about how you can make your rights greater, increase your rights, reduce your risk as an employer, reduce your liabilities as an employer. There are lots you can do. We have an HR checkup document. If anybody's interested in reading more about how you can put yourself in a stronger legal position, just shoot me a quick email. I'm happy to send you the HR checkup document, which we'll talk about that in a lot more detail. And having said that, I'm happy to take some questions. Before I do, I'll just flip to the last slide. I will encourage you guys to keep up to date on things using, I mentioned the running blog, follow our social media, sign up for our newsletter if you want to get things straight in your inbox. You'll get employment law updates straight to you. So feel free to sign up. Again, there's no cost, no obligation. But the last thing I'll say, and I said at the beginning, none of this replaces legal advice. So if you think you might need an employment lawyer, you probably do. Feel free to reach out. We're happy to talk to you. If we can help, that's great. If we can't, then no harm done. But that's all I want to say at this point. I know we're fielding questions. It seems like around the clock these days. So I'm just looking at the chat box. I don't see any more questions, but if there is anything you want to chat about, then I'm happy to stick around for a few minutes And if not, feel free to reach out to me offline, and I'm happy to talk to you there as well. I'm just going to grab some water, and feel free to ask any questions if you have them. You're very welcome. Thank you for the comments. I appreciate that. I'll give it another minute if anybody has questions. Otherwise, a couple of points I should make. If you'd like the slide deck, feel free to email me. I also have, like I said before, we've done a ton of webinars, so I've got a lot of slide decks that are a little more comprehensive because a lot of them are for hour-long sessions. So if you'd like some more detailed slide decks, feel free to email me, and I'm happy to share those as well. Just to at least give you more information than you may have gotten from this one, since it was fairly quick. Oh, okay. Thank you, Nora. So the question is, two more questions. So first of all, Nora, do we need to provide staff with masks? Is that mandated? Simple answer is no. There's no rule that will apply across the board to all workplaces as far as safety equipment. As I think we all know, I mean, Ontario in particular has been great about releasing guidelines on safety in the workplace, and they've done it for every different industry. I think it's about 90 different industries. So if you haven't already, have a look at the guidelines from the province or whatever province you're in. The ideal is still remote work. So if someone can do their job remotely, that's the best. Otherwise, physical distancing, which is why a lot of our clients are reconfiguring the workplace. But it's not one size fits all, and it's not only one. So you can have physical distancing and PPE. And masks have been shown, from what I'm hearing from the medical authorities, they've been shown to be very effective. So you don't have to, but you have to take all reasonable steps to protect your employees. So masks are going to be appropriate in many contexts, and I would encourage you to strongly consider it. And unless there's a good reason, then I would say that you should provide them. So that's, there is no law that you have to, but I would strongly encourage you to provide masks. And Michael, I see, has a question. One of my clients said that you can negotiate with staff to waive the 13 weeks and extend it to as long as a year. So interesting question. Simple answer is no. You can never negotiate out of employment standards, whether that is overtime or vacation or holiday pay or layoffs. You can't negotiate that. What you can do a few things. As I mentioned, you can bring people back from layoff, rely upon the subsidy if you're eligible. That way you avoid the whole issue. But if you can't bring them back, what you can do is you can have there be a deemed termination, in which case they would be entitled to their statutory entitlements, which is essentially a week per year. You can agree that they're not going to get any more, but you can't negotiate around things in the Employment Standards Act. So I'd be very cautious about doing that. Again, you can negotiate around what the consequences might be, but not the actual requirement. Okay, I think I'm just going to take Michael's question and then Jessica. So Michael, is there any chance that the government will step in and extend it? I am certainly expecting them to, and some provinces already have. I believe BC has, some of the maritime provinces have. I can't recall if Alberta has or not, but I would not be surprised. I mean, I think we are all hopeful that 13 weeks would be more than enough time, but here we are mid-May, or mid to late May, I suppose, and it looks like it's going to be a while. So I would not be surprised at all if the Ontario government and the rest of the provinces follow the few that have and extend the time period, but it hasn't happened yet. So be very mindful of that. Jessica, I think you have a question. Thank you. Does your employer legally have to tell you if someone you have been working with tests positive? What are the rules around these things? Yeah, great question. I've had that question as well. So it kind of gets back to what I was saying before about testing. We're always dealing with privacy rights. So first of all, you have this duty as an employer to take all reasonable steps to provide a safe work environment. So if you find out somebody in the workplace tested positive, I would say there's definitely a duty to make the people that were exposed to it or could have been exposed to it aware of that. Where I think you're going to see different responses or a bit of a debate is how much information they have to provide. In other words, do they have to identify the person? And my view is, unless you absolutely have to, you shouldn't. If there's no other way to make the person aware of the risks, then you may have to identify the person who tested positive. Otherwise, I would definitely say not to disclose the name of the person, but make sure that anybody who might have been affected is aware that someone tested positive. Let's see, we got a couple more questions, and I'm happy to stick around for a few more minutes. Michael, I handle quite a few dentists. There's no chance I'll be back to work in less than 13 weeks. We work with a lot of dentists as well. And actually, Michael, I'd be happy to speak with you offline about how we might be able to work together, because we have a significant practice focusing on the dental industry. And yeah, I know they have been so hard hit. And I know a lot of them are now talking about getting back to work. Some of them were open, at least reduced hours to deal with emergencies. But yeah, I mean, and part of the challenge for most of them is they didn't have the right to lay people off in the first place. Most of the dental practices I work with don't have strong HR policies or documents in place, which is another way we might be able to work together. So please do feel free to reach out. But to your point, it's probably going to go more than 13 weeks. If they can rely upon the wage subsidy, that's the best way to go. Recall people, but they may not have to pay them anything other than the subsidy. If they can't, then they may be deemed to have terminated the employees, but hopefully they can negotiate a return to work plan, which will minimize the amount they have to pay. And I can talk to you about that as well offline. There are ways to work around that. You just can't negotiate out of the ESA time limits. Oh, sorry, I thought it was a question, but thank you. So thank you again, Michael. Appreciate the comments. I guess we'll make it last call. Any other questions? All right. Well, listen, I do appreciate you guys for tuning in, and appreciate the questions as well. Like I said, please feel free to reach out. Happy to send you this slide deck or a more comprehensive slide deck. Happy to sign you up for the newsletter, and happy to chat with you. So feel free to reach out. And please do connect with me on LinkedIn if we're not already connected. And I guess that's all for now. So I now have to figure out how to sign out. I figured out how to sign in and share my screen, but I need to figure out how to actually sign out. So I will try to do that. But thank you very much. Take care, stay safe, and most importantly, stay informed.